Hood Talk News, we on fire.
Yo, 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 what's good, what's good? Man, we got another one for y'all today, man. We got this dude, man, he's breaking down, you know what I'm saying, the Keefe D Tupac murder trial, man. And he basically saying, man, you know, by Nevada laws, you know, they can't really prosecute Keefe D on his own bragging rights. You know what I'm saying? By him coming out, writing the book, he says a law that they can't really prosecute him on that. You know what I'm saying? He's saying they gonna really need Suge because he's the only really living witness that was 3 feet away from the car. You know what I'm saying? That really knows who did it. So, you know what I'm saying? They really gonna need Suge to testify is what he's saying. Or Keefe D might be walking up out of this. But y'all, hey, listen, with no further ado, let's get into what he's talking about.
There is one asset class where the buyer is the government and the price is the rest of your life. And people keep selling into it anyway. It's called a confession. And this morning in Clark County, Nevada, they begin picking a jury to decide who killed Tupac Shakur. Every outlet in America is covering the same story. Who pulled the trigger? 30 years of theories, the white Cadillac. But I did something else. I pulled the court records yesterday, the Nevada Supreme Court order, the corpus delicti cases, and the judge has to apply the 32-year delay precedent, the specific intent rulings that decide this. So 3 things came out of that reading, and none of them are what you're being told. The 2 defenses every commentator is repeating right now, the 2 of them sound strongest on television, are the 2 that Nevada law handles the worst. They're close to dead on arrival. And the case files say so in plain words. The defense that could genuinely win this, almost nobody's discussing. And the reason that this trial exists at all 30 years later is not new forensics and not a witness who finally talked. The prosecutors put the reason in writing themselves. It was a book. This is day 357, and
I believe that book, y'all.
read the filings. All right, let's start with where we actually are, because most of the coverage is loose with the details, and the details carry the whole thing, in my opinion. There's Dwayne Davis, known as Keefe D, is 63, arrested September 29, 23, after Las Vegas police searched his home in Henderson. In custody since. This morning, jury selection began with Judge Kearney in Clark County District Court. 4 to 6 weeks is expected. 1 count, first-degree murder with use of a deadly weapon with a criminal gang enhancement. District Attorney Steve Wilson waived the death penalty, so the exposure is life. The state is not arguing that Davis fired the shots. That choice is the entire architecture of the case. Prosecutors say that Davis was the shot caller and that he obtained the gun.
Once again, right? If Davis so much of a big liar, how y'all know he wasn't the shooter? Because he said it. So, therefore, you might as well let him out if you believe in everything he say. He telling y'all he wasn't the shooter. Man, this man finna walk his way up out of this courtroom because they listen to what this fool say, man. He told y'all he wasn't the shooter, so you believe him. Come on, man.
And handed it to the men in the Cadillac. The man they say actually fired, Orlando Anderson, was Davis's nephew, and he was killed in Compton in May of 98 in a shooting with no connection to this one.
I'm pretty sure Keefe D lawyer said, yeah, we gonna do this for this money, but only way you ain't gonna go to jail if you just say it was Orlando that did it. Don't put yourself in the seat saying you shot him. You know what I'm saying? Because they might come arrest you on that one. But let's just stay on the safe side. Which's lawyer probably already knew. I think he said lawyer dead now. But which's lawyer already knew, hey, man, you put this out there, they coming to get you. Lawyer probably already knew he had 3 weeks to live. He ain't care. He ain't care. He just want the money. He like, man.
So remember that choice, though. Everything downstream runs through this choice. Now let's go through the first defense that you have probably heard 100 times this week in describing the case. You can't convict a man on his own bragging. That's the argument. It sounds airtight. Every panel show says it is. And in Nevada, it is far weaker than it sounds, though. And I can show you why. Because
well, hold on. Now, that might be for Nevada, but don't y'all remember G-Dep that was signed to Diddy? Came like 20 years later, could be longer, and admitted that he killed somebody and they locked him up. He out now, but they locked him up. They gave him time for that. So I don't know. Nevada must be different from New York.
Because the cases are public and you can actually go through them. And that's what I did. Nevada has a doctrine called corpus delicti, Latin, the body of the crime. The rule says that the state can't use a confession to prove a crime happened. It needs independent evidence first. So we've got two Nevada Supreme Court cases that have set this test. Sheriff versus Dada, 1999. Sheriff Washoe County versus Middleton, 96. Both say the same thing. To establish a corpus delicti in a murder case, the state must show two things: the fact of death and the death occurred through the criminal agency of another. So if you apply that here, Tupac Shakur was shot 4 times in a car on Las Vegas Boulevard on September 7th, 96. He died 6 days later. The fact of death is not in dispute. Death by criminal agency is not in dispute. Nobody in that courtroom will argue Tupac died of natural causes. Corpus delicti is satisfied before the state calls a single witness. And now the part that the panels are missing completely. The rule covers whether a crime happened. It says nothing about who did it, though. So here is West versus State, 2003. I'm reading the court's own words. Quote, the corpus delicti must be established before evidence of a confession or admission may be considered to prove that the accused was the criminal agency that caused the victim's death. So if you read that slowly, because it does the opposite of what people assume, it gets interesting. It says that the confession is the permitted vehicle for proving identity. Once the threshold is cleared, the court is describing what order his words have to come in. Middleton says it from the other side. Quote, once a state presents independent evidence that the offense has been committed, admissions and confessions may then be used to corroborate the independent proof. So, and we go back to Dada, goes further in adopting the lenient federal standard. Quote, there must be substantial independent evidence which would tend to establish the trustworthiness of the defendant's statements. So that's corroborative evidence need not be.
Boy, Keefe D win this case, man. Every criminal in Nevada gonna use this case to get out of trouble. They gonna go on to write books. If you ain't got no evidence other than them saying that they killed somebody, man, they going on writing books and everything now. And then when you come for them, they gonna say, hey, listen, remember the Keefe D case? That's what the lawyer gonna bring up in court. Yeah, hey, he got off on the same thing now. Now, come on.
Sufficient, independent of the defendant's statements to establish the corpus delicti. So what does the state actually owe? Evidence that his statements are trustworthy, not independent proof that he did it. And that is a low bar. And the physical facts of that shooting match the account that he
Well, he ain't trustworthy.
It clears it. But the confession defense is a television argument. It's not a Nevada legal argument. So now we get to a question that I haven't heard anybody ask yet. And it's the one that explains why this case looks the way that it does. Why is the state prosecuting a book? That's really the question.
Because they just want to close this case, man. They going to say Scooby-Doo killed Biggie in a minute just to close it, man. Come on, man.
There were 2 men in the front of the BMW on Flamingo Road on the 7th of September, 96. One of them died 6 days later. The other one's still alive. Suge Knight was driving. At least 13 rounds went into that car. He was hit in the head by fragmentation and he survived. And he still carries the fragment. He's the only living person who was in that car when the shots were fired. And in 30 years, he's given the state of Nevada nothing about what happened that night. In the months right after Tupac died, Knight told ABC News that he would not help investigators. His reason, in his own words, quote, I don't get paid to solve homicides. The eyewitness, publicly and on the record, declined to participate in the investigation of a murder he watched happen from 3 feet away.
See, and then, even if Suge take the stand, what I'm looking at, you know what I'm saying? And I think Suge doing this on purpose. You know what I'm saying? If Suge take the stand, all the defense lawyer got to do is say, look at this interview. He said he ain't do it in this interview. Now Suge coming a recent, TMZ interview and basically saying, Keefe D is full of it. He was in the car, he did it. The book is real. You know what I'm saying? In so many words, that's what Suge was saying. So, I don't know if Suge gonna be credible. You know what I'm saying, in this trial if he do take the stand.
And once you know that about Suge, the legal architecture that I just walked you through before stops being abstract. Corpus delicti exists so that a person can't be convicted on their own words alone. Accomplice corroboration under 175.291 exists so that the people around a crime can't convict each other by pointing fingers. Both of these doctrines are about the danger of a case with no independent voice in it. The state is in that position here because the one man who could have been that independent voice, Suge, has spent 3 decades refusing to be. So you've got 2 people who could settle what happened on that street.
His
And
word
they're
ain't
the
gonna be
ones
no
that
good
one is dead
anyway.
and one won't speak. And that left a third man who was in the other car to...
Man, Suge done told too many stories for them to even pull him on the stand. This man well, he do got a public defender. He might don't say nothing. hey, somebody say boy got a lawyer on eBay.
write it down himself and sell it as a memoir, which is what happened. That is why the book is the case. Not because prosecutors got lazy or got lucky, but because the witness went silent and then the defendant did not. Suge Knight is in a California prison right now, serving 28 years for a 2015 hit and run in a Compton parking lot that has nothing to do with this particular case. And the week jury selection started, he broke his silence about this trial. From prison to ABC News, he said that this trial has nothing to do with him and that if somebody brings him there, it's going to hurt whoever.
So why should keep talking? Should just shut up, man. If you don't want nothing to do with this trial, if you ain't gonna help it out, just shut up, man. Why'd you keep doing interviews and talking? I know you need honey bun money, man. Stop it.
Brings him there. He promised that. And then he said, leave me out of it. He is on the state's witness list, along with more than 200 other names. Being on a list is not a subpoena and it's not a testimony. So we'll have to see whether prosecutors call him and what he does if they do.
Suge going on all these platforms saying anything because he know they going to say, man, we ain't calling this dude. He ain't credible. He want them to X him out. You know what I'm saying? He want them to X him out.
That's still an open question. So let's talk about the second defense now. It's been 30 years. There is a case almost exactly on point, and it went the other way. Wyman versus State, Nevada Supreme Court, 2009. Complaint filed roughly 32 years after a death. The defendant moved to dismiss for pre-indictment delay. Her argument is the one that you would have to make. Witnesses had died, no new forensics, too much time. Denied below, affirmed on appeal. Here is the test, quoting the opinion. To succeed on a due process challenge to pre-indictment delay, the accused must make two requisite showings. One, that he or she suffered actual non-speculative prejudice from the delay, and two, that the prosecution intentionally delayed bringing the charges in order to gain tactical advantage over the accused, or that the prosecution delayed in bad faith. So we've got both prongs, not either. Dead witnesses did not carry prong one at 32 years because the prejudice had to be specific rather than memories faded and people are gone. And prong two means proving prosecutorial bad faith, which is very hard when the state's answer to why now is, quote, because he started confessing in public. So there's a hard irony in that record. The delay argument is destroyed by the same thing that revived the case. He talked. Judge Kearney already denied this. In January 25, she found no proof of the binding immunity deal, and she noted that the state had no incentive to sit on the case because it was Davis's own book that triggered the grand jury. That's a judge in an order saying the book is why the whole case exists in the first place. Let's take a pause here, a quick word before the part that changes the case. If you want the primary documents behind these videos, the case numbers, the filings, the paper that I actually read, that's going to go out in my newsletter. It's free, eventhorizoниq.substack.com. There's going to be a link in the description. I put the receipts.
I think all this is about they want to close this case, man. Y'all, I think this dude gonna walk out the side door, man. Come on, man. If he telling y'all, right, in Nevada, you can't use a person's words, they bragging rights against them. You know, how they gonna convict Keefe? You know what I'm saying? There ain't no witness left. Man, it's been 30, 40 years, man. Ain't nobody around. Everybody gone, man. He the last dude left, man. I think they gonna ride him out for a minute and they gonna let him go, man. They gonna let this dude go. Especially if Suge, the only witness left, and he's not taking the stand and saying nothing. Man, who else they got? Wasn't nobody else there. Like it's just his own, you know what I'm saying? And then he ain't credible. His own lawyers calling him a liar.
There so that you can check me rather than trust me and go through them yourself if you're interested. So where does the defense actually live? Remember that the state's choice, they are not saying he fired. So they have to prove aiding and abetting. And Nevada is unusually demanding about what that takes. Sharma versus State in 2002 controls the mental state. Quote, in order for a person to be held accountable for the specific intent crime of another under an aiding or abetting theory of principal liability, the aider or abetter must have knowingly aided the other person with a specific intent that the other person commit the charged crime. So specific intent that the other person commit the charged crime, not that he was present, not that he was in the car, not that he was handed over a weapon during a confrontation. And then we have a Bolden versus State 2005 does something most states have never done. Nevada abolished the natural and probable consequences doctrine for specific intent crimes. The court called it unsound and noted the absence of any statutory basis for it. In most of this country, a prosecutor can stand up and say, they set out to confront a man and a killing was the foreseeable result, and that's enough. In Nevada, the sentence is not available. The state can't reach first-degree murder by arguing that death was foreseeable. So Davis puts himself in the Cadillac by his own account, so presence is conceded. The contest is whether the state proves he intended a murder rather than a confrontation, and how the jury gets instructed on the difference between those two. So jury instructions are where this is going to be won or lost or reversed.
He said he went to kill him, man. Dirty Teeth Keefe went to kill him, man. He told everything in the book, man. I believe him, man. Y'all need to be looking at that book, man, because everything he said in that book should add up to what the detectives have in their files, man. Come on, man.
Years from now. That is the unglamorous truth, and it will not lead a single broadcast tonight that's talking about the case. Now, the immunity claim, because his lawyers have pushed it the hardest, and it has already failed twice when they've tried. Davis says he gave his account under a proffer agreement with law enforcement, and that those statements can't be used to prosecute him. In January of 2025, Judge Kearney, denied that motion. His lawyers took it up, and on November 4th, 25, the Nevada Supreme Court denied his writ petition, docket 91041. So read what that court found. It described the agreement he relies on as federal and dating to 98, and it held that Davis failed to establish that Nevada was bound by its terms. So that's the problem in one sentence. A promise made by one government doesn't automatically bind a different one. Separate sovereigns, separate prosecutors. Prosecutors made a second point that is harder to answer. Whatever confidentiality he believed he had, he destroyed himself by telling the same story in a book that he sold on television and in interviews where he was paid for it.
But that's so crazy, right? He tell the story one time, man, they should be able to convict him. Straight up. He told it once, you know what I'm saying? Straight up. You know what I'm saying? I don't understand how this stuff work, man. But it's crazy how, you know what I'm saying, he can tell the story at any time and get away with it. That's crazy, man.
So there are two rulings here, 4 weeks apart, and almost everyone covering this has merged them into one. On June 30th of this year, Kearney ruled the memoir admissible. Compton Street legend comes in. She found Davis adopted the book as his own statements, and she pointed to him publicly telling people to buy it to get, in his words, the real truth. The defense argument was that a ghostwriter invented the details and that the co-author had said he wrote the whole thing from conversations and ad-libbed it in places. But Kearney held it did not matter how much of Davis personally wrote it, he adopted it. So then on July 28th, separately, she ruled that the 2008 police interview recording admissible too, rejecting the argument that he had been speaking under a confidentiality understanding. So she ruled that the book is attributable to him. She did not rule that a word of it is true, though. So those are completely different findings, and the only one of them is a fact about the world. And now the detail that almost nobody has noticed, which matters more than the ruling itself. The Nevada Supreme Court denied that the writ on procedural grounds. It said a motion to dismiss is the wrong vehicle. It expressly did not reach the immunity question on the merits. So the issue is preserved. If Davis is convicted, it goes up on direct appeal on a clean record. A conviction in this case is not the end of this case, in other words. All right, so we are going to come back to the real question here in this case. It's not why did it take 30 years? Why is it happening at all, I think is the real question. So 27 years of...
Why is it happening? In Keefe D's word, they wrong, man, they wrong.
Conventional homicide work produced no chargeable case. And the 2008 interview sat there and nothing moved. What moved it was a memoir called Compton Street Legend, published in 2019, a 2018 BET docuseries, a paid interview circuit. And the state said so in writing. Their January 2025 filing, quote, after defendant began to publicly confess in a detailed manner his involvement in the crime, the state chose to rely upon those confessions to seek to prosecute. The state's evidence never improved. The defendant's incentive structure changed. The evidentiary record...
One thing I don't get, right? When the state bought this case on, right, and they say, okay, we finna arrest this dude and everything, they didn't know they laws. You know what I'm saying? That's why I say I think there's just a quick way to close the case, to get it out the way. Las Vegas ain't got to deal with it no more, and they'll be done with it. Because once it's a done deal, man. And then they gonna bring Biggie case next. You know what I'm saying? They gonna find somebody they don't say, and they gonna close that case too. Because they just tired of it, man. They tired of it. They ready to just get this out the way, man.
In this case was assembled by media producers rather than detectives. And this prosecution is built out of content, which produces the strangest inversion that I have ever seen in a criminal trial. The prosecutor's job is to argue that Dwayne Davis is credible. The defense lawyer's job is to stand in front of 12 people and argue that his own client is a fraud, and that the statements were never admissions, that they were just exaggerated stories to sell books. So on day 344 in this series, I read the paper trail on Tupac's masters. The thing at the center of it was that Tupac's freedom, the bail that got him out of Clinton Correctional in 1995, was collateralized against his own unearned royalties. He mortgaged himself through other people. 30 years later, in the same story, a man sold the only asset that he had left, not a catalog, not masters, but his confession. The label did, the estate did, the catalog sold and sold again. Documentarians did, podcasters did. The retired LAPD detective who took the 2008 statement, Greg Kading, wrote his own book about it, and he's on the witness list, so he'll testify about evidence that he obtained and then published. Investigator, author, and witness in one person. His cross-examination is the highest leverage moment in the trial to watch for. Everyone in the true crime.
Man, this case seemed like a 50-50, you know what I'm saying? It's all up to the jury, man, at this point, what they believe, you know what I'm saying? And I heard that you got 10 women and 6 men, you know what I'm saying? And they say a couple of them, they say the youngest is 20-something. So, he might not stand a chance with the jury. They might be biased because everybody love Pac. You know, especially the young people. He probably would have had a chance with some old people that wasn't really into Tupac, you know what I'm saying? But these young people, man, these generation, man, my kids know who Tupac is, man. They coming out knowing who Michael Jackson and Tupac, they guaranteed to know who they is, man. Them kids gonna be biased, and I hope they be biased. For real.
Economy.
Because, man, Keefe ain't come tell this story for nothing. Y'all gotta think about it, right? Why would Keefe D come out and tell this story? All right? What, Orlando told him the story? And I want to know who approached who. You know what I'm saying? Did he approach the people on this one day after 30 years later? You know what I'm saying? Did he approach the people and say, hey, man, let's do something on I Killed Tupac? Like, it don't make sense like somebody to really come up with a plan, right? For no money, because I don't care what he say. He ain't make no money, man. The man got a public defender, man. He ain't make no money. So who came up with this plan to say, hey, Keefe, you want to make some money? Just say you killed Tupac. Now, that's a dangerous game anybody would want to play. Because Tupac is well loved on the street. You might get a fan that take you out. You know what I'm saying? So that is a game nobody finna play for money. You know what I'm saying? Unless it's the truth. Now, only way I feel he thought of that is because he know he was involved. It was the truth. He was like, man, hey, listen. You know what I'm saying? They offered him a deal that he couldn't refuse. 2 cold Coronas in an 8-ball. And he jumped straight on it, lied, talking about he made $150. And then, after he did that, $150,000. Then after he did that, y'all, other podcasts were coming, and they was offering a little more. A 24-pack of Coronas and 4 8-balls. And he felt he could put his whole life on the line for that. And he came out here and he said, yeah, we did that, we did. He too proud of that moment. You know why? Because he really wanted Suge. He was that jealous of Suge. Listen to how the story, all the stories, how they lead up to him and Suge. How, we started Death Row. Them guys around Suge had so much plex for him, man. They wanted him out of there, man. It seemed like he the only one from their generation that made it. That what it seemed like the biggest. And they was jealous because Suge wasn't a gangbanger. He from the neighborhood, but he the guy that went off to college and played football and all that stuff there. He wasn't like them. He was the square to them probably. And they looking like, man, look at this square done made it. And you know what the hood do to squares? They try to bully their way in. And that's what happened. and Suge wouldn't let him in. So them dudes got jealous. They got so jealous. Big U said Suge it wouldn't be no death row when he was out on the street. Why would you want to stop another black man from accomplishing something? You should have just said, hey, if I was on the street, death row would have been more powerful, and Tupac wouldn't have died. But that show you how much of cowards these guys is. How much jealousy in their heart. They want to take somebody down because it ain't them. Come on, man. We see this happen every day with people. Once you get successful, they want to take you down because it ain't them. But, man, this God plan. It ain't ours, man. So when you fight against them, the people that's successful, guess what? You fighting against God because he don't make no mistakes. The reason they there and you're not there is a reason. Wait your turn, man. And maybe your turn ain't come yet because you got so much hate in your heart, man. And this how, when you got so much hate in your heart, guess what? This how they end up. This how you end up, man. Messed up. Because of that hate drove you to do something you ain't want to do. Like hurt somebody. Because jealousy killed. Look what happened to Nip.
Monetizes proximity to violence. That is the business model. But almost all of them are selling somebody else's crime. Davis is the only one who sold his own. And whatever a self-published memoir and
sold his crime.
Paid,
you heard Buddy said, y'all heard what Buddy said? He sold his crime. This is some new stuff, y'all. This is some new stuff. The criminal could sell his crime now, thanks to the internet. But they don't want the consequences that come behind it, y'all. They coming.
He took on was life without the possibility of parole. And that is the worst trade in the history of the entire music business. Okay? So there's one last document, and it may decide everything in this case. Days before the trial, Davis told reporters, quote, "I wasn't in Las Vegas," and, quote, "why would I kill our money?" Hold that against his own memoir, his own 2008 profit, and his own 2018 BET interview. All three put him in that Cadillac.
Boy said, why would he kill their money? He done turned so delusional, and see that's what I'm trying to tell you, y'all. That's jealousy. That is, he was so jealous. In his mind, he started feeling like he had something to do with death row. He said it. Southside Crip started death row. I'm the one who started death row. Bro, we never heard of you into this. Nothing about you connected to death row until you did this, bro. Come on, man.
He has now told two irreconcilable stories about the same night. One of them is a lie. The jury does not get to decide that both are true. So a case about ballistics in a 30-year-old crime scene comes down to something much simpler. 12 people in Las Vegas have to decide whether the lie was then when there was money in telling it, or now when there is a life sentence in it. Which moment did he lie? I think there's three things to take out of this whole case.
And I think another thing, I could be wrong, but is it the fact that Suge, you know what I'm saying, played football and grew up with Keefe D? That means Suge, right? I could be wrong. You from LA, let me know. Doesn't that mean Suge came up from that same neighborhood around that same set Keefe D was down with? Right? And if I'm correct, that means that they got mad, like I said before. Suge came up over here, but he gave work to the other side. And I believe that's what Keefe D was mad about. Correct me if I'm wrong. You know what I'm saying? I believe he said, you come from my side and you over here giving these dudes jobs. You know what I'm saying? And I think it was all about that. He got jealous and mad, man. You know what I'm saying? Because he even said, dude walked through the crowd and came up and he shook my hand. And everybody looking at me like, who that dude is? Suge Knight shaking his hand. You know what I'm saying? He wanted to be a part of that. And all he got was a handshake. That's all he got, y'all, was a handshake. No money, no nothing. All he got was a handshake. He ain't like that.
For everybody watching, number one.
And that was, what he say, 2 days before the murder, if I'm correct? 2 or 1 day before the murder? Come on, man.
The two defenses dominating coverage are the weakest ones that he has. Nevada's corpus delicti rule stops short of identity. So his own words are allowed to do the identifying. And Wyman already rejected a 32-year delay claim on facts stronger than his. Number two, the real fight is the specific intent, and it's genuinely live. Nevada abolished the foreseeability shortcut so that the state has to prove he intended a murder rather than a confrontation. So watch the instruction conference, not the testimony. Whether that jury gets a lesser included offense to reach for is the highest leverage unknown in this trial right now. And number 3, this prosecution exists because a man monetized his own confession, and the state said so in its own filing. That's a mispricing. He sold his story into a market that pays for proximity to violence, and he never.
But y'all heard what he said. Nevada laws, you can't be convicted over your own confession, your own bragging. You know what I'm saying? That's what he said the law is.
The one buyer who is always going to show up for it. If you want the closest analog to how this ends, it's not a celebrity case at all. In 2019 in Compton, prosecutors argued that the rapper's lyrics and videos proved that he led a violent gang and ordered a killing. The jury acquitted him of murder and hung on conspiracy. His co-defendant, the alleged shooter, was convicted instead. That jury separated the trigger from the man that they said gave the order, and they let the second one go. Every filing that I read for this is in the newsletter, free at eventhorizoniq.substack.com. It's the same process.
Man, the prosecutor gonna have to, prove that Keefe D, it could be a chance he pulled the trigger, man. For real, man. Because he's telling y'all that he was the guy that orchestrated whatever. You know what I'm saying? Like, I seen a woman get life on orchestrating a hit on her husband, and they ain't even killed the dude. You know what I'm saying? So I don't understand how Keefe D orchestrating, you know what I'm saying, don't mean nothing. Now, I believe he was the shooter, man. The more I listen to this dude talk, I think he's just trying to wave his way away from being the shooter. I think he was the shooter, man. I think Orlando and Big Dre and all them was like, man, nah, man, it ain't worth killing the dude. I don't want to kill the dude, because if you listen, when Keefe D said they ran in the lobby and they seen Orlando, and Orlando said some death row dudes jumped on me. That's a big deal, y'all. That's a big deal. He said some death row dudes jumped on me. He didn't single out Tupac like he wanted Tupac. Keefe D said this out of his own mouth. He didn't single out Tupac. He said some death row dudes jumped on me, man. So that led Keefe D. Keefe D didn't even know about Tupac at that time. He said some death row dude. They didn't know about Tupac until they seen the video. And that was way later. But he said some death row dudes. So know what Keefe D did? He went and got some guns because he was that jealous of Suge. He wanted to hurt Suge. He wasn't thinking about no Tupac. He even said when they shot in the car, they thought Suge was out of there. But it hit Tupac. And I think they were mad it hit Tupac because Keefe really wanted Suge, man. Y'all don't see this, man. Come on, man.
Every day here, we show up, we put in the work. It compounds over time, and we benefit from it. Thanks for watching. Click on the bell if you're...
Hey, man, listen, man. Dude just broke it down, man. Shout out to him, man. You know what I'm saying? But like I say, man, Keefe might walk on this, man. Keefe might walk on this. You know what I'm saying? I hope it don't. But it's going to be up to those people in the jury to believe this dude's words are the truth. You know what I'm saying? It's up to them people, man. They gonna need some type of witness or something, man, to get this dude good. I don't know, man. Like I say, this case is 50-50 to me. He can walk or he can get time. And that's gonna be up to the jury, man. Hey, man, listen, man, I just came to bring y'all that. Don't forget to hype me up, y'all. Show your boy some love, man. Like, share, and subscribe. You rocking with the realest platform on the planet. Hood Talk News. I'm out. Yeah.
Make it double.
G-Track broke this beats to life.
Way too cool for sports, too fucking clean for some golden gooses. Pull up on these shits, we poppin' out, nigga, we making movies. Haters wanna know how we do it, my teacher say I'm a good influence. Put me in a room next to the back, watch me start speaking fluent. Long as my mama good, long as my daddy good. She consider me the modern day Robin Hood. We get this shit poppin', could've stopped it, nigga, if you could. We get this shit poppin', we droppin' niggas off some love. Respected by the realest thugs, never been a thug, but feel every thug needs some love. Caught up in the matrix, wrist shining like Mike Glove. Another 150, that big gon' shine like a light bulb. We gon' keep it slight, cuz any nigga might budge. He ran and got his fellas, cause he jealous and they don't like us. I'm trying to tame the beast and keep the peace, but they ain't right, bruh. They wanna start the beef from living life and they ain't like us. Way too cool for sports, too fucking clean for some golden gooses. Pull up on these shits, we poppin' out, nigga, we making movies. Haters wanna know how we do it, my teacher say I'm a good influence. Put me in a room next to the back, watch me start start speaking fluent. Long as my mama good, long as my daddy good. She consider me the modern day Robin Hood. We get this shit poppin', could've stopped it, nigga, if you could. We get this shit poppin', we droppin' niggas off some love. And haters wanna see us go, we poppin' out this bitch like a motherfucking TV show. More baddies than the baddies, and I ain't tryna get married on some upscale shit. And lil' mama a little savage, goddamn, can I grab it? I'm just playing, but can I grab it? They say the way I flip this money, I should be in gymnastics. Say the way I kill this beat, you should dead it in a casket. Watch the way I'm pulling up, matte black, so nasty. Slow mashing, I let them pull past me. Once I hit the gas, man, they know it's no catching. Competition waiting, faking, hating for no reason. All my competition might be dead or in prison. Now I see the vision, stay true to your religion. She made them catch the Holy Ghost, she popped it like a pistol. She made her spin up all this dough by acting like she miss him. Now he got issues, give his ass a tissue. Way too cool for sports, too fucking clean for some golden gooses. Pull up on these shits, we poppin' out, nigga, we making movies. Haters wanna know how we do it, my teacher say I'm a good influence. Put me in a room that sit up back, watch me start speaking fluent. Long as my mama good, long as my daddy good. She consider me the modern day Robin Hood. We get this shit poppin', could've stopped it, nigga, if you could. We get this shit poppin', we droppin' niggas off some love. Way too cool for sports, too fucking clean for some golden gooses. Pull up on these shits, we poppin' out, nigga, we making movies. Haters wanna know how we do it, my teacher say I'm a good influence. Put me in a room next to the back, watch me start speaking fluent. Long as my mama good, long as my daddy good. She consider me the modern day Robin Hood. We get this shit poppin', could've stopped it, nigga, if you could. We get this shit poppin', we droppin' niggas off some love. Pull up on these shits, we poppin' out, nigga, we making movies. Long as my mama good, long as my daddy good. She consider me the modern day Robin Hood. We get this shit poppin', could've stopped it, nigga, if you could.